horses and have fun with. It's not mandatory that they be educated into the nuances of what we're talking about today. So they don't necessarily want to know that. When people come to a 2-year-old in training sale, they might be interested in 2 things. How fast did that horse breeze, and who's it by? I really like that Pioneer of the Nile colt that breezed in 10 flat. That's the full extent of their thinking when they're trying to buy a horse. They don't want to get into this discussion, but they might have some very different ideas about it after the fact if they find out a horse has some little issues that probably are going to be fine, but that they weren't aware of. So what I'd like to do is I'd like to, guys, get your PowerPoint going here. Mike, if you want to run that, and we can, go through some. What I'd like to do is go through some scenarios with you, and some of these are real scenarios that have actually taken place at sales in recent times.
Okay, let's see if I can get this to work. I think I got it. All right. Jeff, do you want to change the pages? As Dr. Berk said, Mike Meusser and I have been involved in discussion of radiographic reports now for almost 3 years. We have talked to groups of veterinarians. We've been in meetings with consignors in the past, attempting to illustrate some of the problems that we see from legal standpoints for all parties, from veterinarians, who I typically represent, to owners, buyers or sellers that Mr. Meusser typically represents, and then even to the sales companies. While at times we've had our opinions on what we believe the best course of action is, that's not really what our intent is here today. Our intent here today is to discuss how the use of the radiograph reports in the back rings as essentially a marketing tool for the horses creates an atmosphere where we all could have problems. Mr. Meusser and I are generally opposite each other when it comes to litigation. And it takes a very rare issue for the two of us to sit down and work together for years without someone pointing a finger at each other. But it's been a good effort, and we hope we're able to highlight some of the issues that we see. You want to start?
So there's obviously a great concern about how these reports are being used, and since their inception, the AAEP and the sales company have both taken public positions about those dangers. The AAEP has talked about the potential to harm all the parties involved at the sales. The buyer may not be adequately represented. The vet who wrote the report has no chance to explain it, and that's quite obvious because that vet wrote that report. It's gone into someone else's hands and it's being passed around. And obviously modifying or deleting findings in the context could be unethical or fraudulent. And the radiographs that are taken, the report is based upon, should accurately reflect the condition of the animal. So both Keeneland and Fasig-Tipton, Keeneland in 2011 did not have anything related to the radiograph reports. In 2012, they added a condition. As you know, it involves a arbitration proceeding if it's found after the sale that the report does not accurately or authentically represent what's in the radiographs. Now, what's interesting to me is when we started talking about this, the group that was most upset with the reports was really the vets, because they were getting worried about their liability for doing the reports. In the last year, what we've heard is sellers complaining about the fact that buyers are not doing their due diligence. Instead, they're buying the horse, having the horse radiographs reviewed after the sale, and if they find something in the report that doesn't match up, they're using that as a way to either give the horse back or to bargain the price down. So this is kind of expanded in terms of how these reports are being used by different parties. Fasig-Tipton, same thing. They have basically the identical condition. There's a panel determination if the report doesn't match the radiographs. So what are the legal issues? Well, the legal issues have to do with things that happen every day at the sale. So what we're going to try to do is not make this a boring legal presentation as much as giving you an actual scenario and walking you through what we see as the issues. So this is our first scenario.
And before we do that, we want to stress that we're not talking about situations where a veterinarian or consignor makes a decision not to report a finding, issue a clean report. We're talking about situations where people are trying to do the right things. That in the veterinarian's mind, there's nothing in that film that materially impacts the horse's ability to perform as an athlete, and writes no significant findings. The problem is that under the current system, under the current status of the law, which is not going to change, there is no protection for the veterinarians or for the sellers, the consignors, if any individual reading that report and purchasing the horse has a different idea of what's significant. And we've attached the industry has attached meaning to the word significant that frankly has no definition. And so keep in mind, we're not talking about what a lot of people like to rely on and saying, oh, we're trying to protect the 1% of the bad actors. That's not the intent. What we're doing is trying to highlight the liabilities that exist for 100% of the people in the room.
And the other thing to keep in mind as we're going through this is the biggest problem with trying to create some uniformity about what these reports say and what the findings are is that there's not a lot of scientific evidence out there for which lesions in a horse's joint are going to create a problem for that horse racing. And so you're left with all the vets who have their subjective opinions about what's important and a very little bit of scientific data out there about what really, as you watch the population go forward, matters in that horse, which makes this problem more difficult. Go ahead.
Okay. It's a long scenario, bear with us. Dr. A has been a licensed veterinarian for more than 30 years. He concentrates his practice in lameness and sales of thoroughbred horses. One of A's best clients is Selimall Farm, a commercial breeder of considerable stature in the industry. Selimall regularly consigns 40 to 50 yearlings at the Keeneland September yearling sale in Kentucky each year. Dr. A is paid by the farm to take repository x-rays and scopes of all the yearlings and prepare radiographic reports and scope reports for filing in the repository. Dr. A uses a standard form report for both supplied by his clinic. And it doesn't read real well, I apologize, but the standard form is the typical views, and each entry says no significant findings. Dr. A's report contains the following disclaimer, and I'm not going to read the entire disclaimer out loud, but essentially it's an attempt to say the report and the findings are designed solely for the person for whom they prepare the report, and no one else has the right to rely on it. On a hot day in July, Dr. A arrived as scheduled at Selimall to x-ray and scope the yearlings for the September sale. The owner of Selimall, Jack Black, is present as each horse is led to the stall to be scoped and x-rayed. Dr. A's standard procedure is to only note lesions or abnormalities he deems to be significant to future racing and training. Otherwise, he simply writes NSF or no significant finding at the location designated for that particular joint. While he is working, a handsome gray colt by Tappet is led to the stall. Jack tells him it's his best yearling out of a grade 1 stakes winner and stakes producing mare. While reviewing the radiograph of the left front fetlock, Dr. A observes a moderate mid-sagittal lucency. Because in his personal experience that particular defect has not caused many problems for racehorses, he records NSF for his finding on the joint. Jim Newby, a young multimillionaire who has just made his fortune from the development of anti-hacking software sold to Ashley Madison, has decided to get into the thoroughbred racing game. Newby attends the sale and immediately becomes focused on the handsome Tappet colt at Selimall consignment. While the coat is being shown, Newby asks Jack Black if the horse has any issues. Jack replies that he x-rayed perfectly clean. Black shows Newby the radiograph report in the notebook and sees that NSF is written to the right of every joint on the report. Based on what he sees, he tells Newby he can be confident in bidding on the colt at sale. An hour later, the Tappet colt enters the ring. The bidding is furious, and Newby eventually is the high bidder at $1.2 million. After the sale, Newby runs into Dr. B, who he has met previously at the bar at the AEP convention a few months ago, and tells him about his big purchase. Dr. B recommends that newbie allow him to review the films, and newbie agrees. Dr. B reviews the film and sees a lesion in the left front fetlock. Dr. B is conservative and knows that he's representing a new buyer with an expensive horse. He discusses the lesion with newbie and tells him the lesion may or may not impact the colt's ability to train and race. Newbie is furious to hear this news. He calls Black and says he did not want to buy a horse with any problems, much less a problem that could keep the horse off the racetrack. He demands a refund of the purchase and threatens to sue if Black refuses. Black says he relied on Dr. A's report that was clean.
So, once you have this scenario, there's all sorts of claims against all sorts of parties that can be based on different bodies of law. So in here, the claims can result against the veterinarian and the consignor under the theories of negligence or fraud. However, what you need to understand is there's a potential legal liability for the veterinarian, the seller, and even the sales company under these different theories. So we're going to go through them very quick. Fraud, okay. Fraud is a claim. A lot of people think buyer beware. The conditions say there's no way you can sue. Fraud is completely outside the conditions of sale, so it's always available as a remedy. It involves telling a lie or the failure to speak the truth. It has to be a material defect. That is, what has been concealed has to be material. The problem is that in Kentucky and a lot of other states, what is material is subjective to that individual buyer. It's not what a reasonable buyer would think is important. The buyer must rely on it, and the buyer must be damaged. However, you as a seller have no duty to inspect your horse to find those problems. The law recognizes that parties may act in concert to defraud. So the allegation may be that the vet and the seller have worked together to conceal a defect from the buyer and commit fraud. And there's joint and several liability, which means one party can be responsible for paying all of the damages even though the other party was involved.
And I want to touch on that for 1 second, the joint and several liability. Most of the veterinarians, I would hope that all of the veterinarians operating the sales are insured. The vast majority of them are going to be insured through the American Veterinary Medical Association. The problem with an allegation of fraud, which if we get into an X-ray dispute in civil litigation, there will be a fraud claim. But the problem with an allegation of fraud is it may void that insurance. And that's where the joint and several liability comes in for the consignors. Then it becomes who's got the deepest pocket to take care of a judgment if there is one. Because if there's no insurance proceeds, then it becomes down to the veterinarian's individual money or your individual money.
And it's very likely that if the seller and the veterinarian who prepared the report are both sued, the seller is going to immediately turn around and sue the veterinarian for indemnity because he prepared the report. So the other one that's even more dangerous is negligent misrepresentation. And this is a body of law that grew out of the Enron scandal back in the 80s, or I guess it was later than that. And basically what happened was the lawyers and the accountants were cooking the books on the company. And when the whole thing fell apart, they got sued and they said, well, now wait a minute. We didn't prepare our reports and our opinions for these people that invested in the stock. We prepared it for the people that were running the company. And so the body of law that grew out of that said that if you provide information to someone knowing that they're going to provide it to a third party and they're going to rely on it in a business transaction, you can have liability to that third party even though you never dealt with them or met them. So the last body of law you need to be aware of is express warranties. And we disclaim all the implied warranties on horses when we sell them, but an express warranty can't be disclaimed. So things that are said about a horse before it's sold can constitute a basis for that buyer to sue. The horse has no problems. We'll stand behind any problem in that ankle. No significant finding. Not likely to affect training. Those are all things that could be construed to be an express warranty. So in this scenario, we've got multiple issues. First of all, how can Dr. A be liable to newbie? He never met him. He prepared the report for Blackstack. And how can he have any liability? Well, that's because in Kentucky and most states, the restatement has adopted the negligent misrepresentation standard. And he knew full well when he prepared that report that the seller was going to use that report to market that horse, and that's how that liability can be created.
The first time we dealt with that issue in front of, it was the Kentucky Association of Equine Practitioners, that was the question I got. I'm working with my client. How can I be responsible if my client takes this report and shows anyone else? And so I asked a very simple question. There's, Jeff, what, 200 or so of us in the room? I asked 200 veterinarians, how many of you know that these reports end up in the hands of third parties? Every single one of them, raise your hand. And once that happens, there is liability for whoever reads your report. So the veterinarian that's sitting with their client talking about what's significant to them or what they believe is significant in selling the horse, by issuing those reports and knowing they're going out to the general public or potentially could go to the general public, that report can be relied on by anyone who reads it. And anyone who reads it who then has a disagreement of what's significant to their own opinions, their own internal prejudices, their own bad luck with previous horses, liability exists for that veterinarian and the consignor.
And there's a couple of limits to this liability theory, but they're really not going to be of much use to the veterinarian or the seller in this case, because they know which group of people are going to be looking at these reports. They know that they're being used to influence the buyers relative to the purchase. And then we finally get to these disclaimers that everybody puts on the sheets. And generally speaking, the law is you can't disclaim liability for your own negligence. If you could, nobody would ever be able to sue anybody for negligence in a commercial transaction. So the disclaimers are really ineffective. What we've tried to tell the vets to do is if they're going to write a report regarding something they did to the horse pre-purchase or pre-sale, define the scope of what you were asked to do very precisely. That's a better way to limit the veterinarian's liability, particularly in the private context, from that kind of a claim. And again, there's not even a direct relationship with the party you're trying to push this disclaimer on. The other thing we've been very concerned about as we've tried to talk to lawyers and veterinarians and commercial breeders about this subject is, these words that are being used on the report. What is significant? I mean, if you look at the textbook definition of significant, it's pretty strong. And it's pretty easy to violate that definition by not disclosing something. So you get into this whole discussion about what should be on the reports. And Jeff and I have argued particularly vociferously about this for a couple of years. Because and again, I don't have an agenda, but if you're going to solve the problem, how do you solve it? Well, one way is to make the reports better, and the other way is to get rid of the reports. Those are really the only alternatives. So if you're going to make the reports better, how do you do that? Well, I argue, and others have argued, that you could standardize the reporting of these radiographic lesions in such a way that vets wouldn't be able to fudge, that all the necessary information would be on the report. The difficulty is there's a lot of scientific terms that are thrown in. So if you start seeing a report as a buyer that has a bunch of findings, then you start to be concerned about whether you should buy the horse when maybe those findings aren't significant to that horse's ability to race. So if we're going to make the reports better and we're going to make them standardized, it's the veterinarians that are going to have to lead that charge. They're going to have to get a committee together, agree about what is significant. It's going to be a moving target because there's new studies coming out all the time about what affects the horse's ability to race. But if you're going to do that solution, it's going to require a lot of time and effort on the part of the veterinarians.
Yeah. It's my mic? Yeah. Yes, we've had that conversation a lot of times. And the problem with creating a report that works is that several things. Number one, you can never get to the level of objectivity that you need in order to make it a useful report. That's number one, and that's based on veterinarians' experience. Number two, as Mike has already said, there's not really enough scientific study been involved on each radiographic finding to know whether that's going to be, how that's going to affect potential racing soundness. And so you'd say, well, why don't we do those studies? And we are. I mean, we're in the process of doing that. There's going to be another big study coming up studying sesamoiditis and stifle lesions within the next year. And that's all great, but there are so many factors that make up whether a horse can run, and some horses, two horses may have the identical radiographic finding. One of them is bothered by it because he's just pea-hearted, and the other one is brave and forgets about it. And so there are too many factors involved. The radiographic findings are just one piece of the puzzle. They're not, frankly, important enough to be universally either a deal breaker or universally okay. So there's some real issues involved with trying to standardize these. If there was a way to discontinue the current practice of using these reports, that would be the best answer if there is a way to do it.
And continue on what we said is the significance of significance. I know there are many people that have said, well, the veterinarians then should just write all of the radiographic findings. Now, I know no one in this room wants that, but the problem with writing all of the radiographic findings is, under the current system, a buyer has no obligation to make any determination as to what radiographic finding means for the horse's ability to race. They can buy it, say I read the report, and if one of those turns out to be important, what we're going to hear from the veterinary standpoint is, well, okay, you told me it's there, but you didn't tell me what it means. So even a system that simply says write all the findings means nothing, because findings without the professional opinion, whether it's based on the veterinarian's track record or the limited amount of scientific knowledge we have as to which findings actually do impact the horse, or may impact the horse, excuse me, a listing of just findings doesn't do anything. It doesn't provide the buyer any information, and it again sets up a situation where a buyer has the ability to say, you provided me this as a marketing tool, I relied on it, but you didn't provide me all the information. You withheld critical information. And you know, I'm seeing this more in defending the veterinarians than the CBA or members of the CBA will see, because there's civil and there's administrative liabilities. The Kentucky Board of Veterinary Examiners has taken a very hardline approach in the last couple of years as to what they believe should be done with veterinarians when they perceive issues of a false report. You know, we've had situations where the Kentucky Board of Veterinary Examiners is seeking to revoke licenses, where the fines they're trying to impose are 5 figures. Now, thankfully, from my perspective, those have not been successful, and we've defended these. But when we have a reaction from the Kentucky Board that starts off with a case where we want to suspend a veterinarian for 2 years, and by the end of the litigation, we're down to the board dismissing that complaint, it illustrates that there is no standard of what should be reported that even the Kentucky Board of Veterinarian Examiners is willing to adopt yet.
And in the case Mike's talking about, you know, part of what he had to do was bring in an expert to say, look, the scientific literature says that's not a significant lesion for racing, therefore you shouldn't be punishing this guy. So these are Jeff's points that he just made, that there's no agreement about what is significant and how do you list everything or just put NSF.
And well, that's a good point about what's significant to racing, because you as consigners know that a significant part of your buying public are people that buy to resell. And they are looking at a whole different set of criteria as far as what's important to them, what they would consider quote unquote significant. And many of them are very smart. It's not that they're stupid. They understand the difference, and we all wish that there was no difference. In a perfect world, a horse that's okay to race would be okay to sell. It shouldn't be a problem, but we're talking about different levels of understanding and sophistication on the part of the buying public, and that's just the way it is. They're not really interested in the nuances of this discussion. So we all are pretty much at the mercy of the person with the least understanding.
So we talked about this a little earlier, but you know, how is this promoting abuse? And the one that I've seen more this year than maybe in the last 2 is buyers using the sheets as a way to create a dispute about a horse after it sells and either knock the price down or give the horse back. And I dare say, from what I've heard just from my clients, more people are either taking the horse back or reducing the price than are going to arbitration. Because, you know, if that report does not agree and the panel says it doesn't agree, that horse is going back anyway. And really the arbitration process isn't really designed to properly address the issue, because, as you know, if that all happens after the sale, then you've got a horse you haven't gotten sold if you lose the arbitration. So who has liability in this whole scheme of things? Well, we didn't talk about it much, but in addition to the seller and the vets, which is kind of the pyramid that we've got going here, the sales company has liability. Because the Chernick case, which has been on the books for 30 years, basically says that they have to make sure that the information that's provided to the buyers is accurate. In that case, it had to do with a catalog description. But once Keeneland and Fasig-Tipton made the decision to put these reports in the repository, they're also exposed for the quality of the information that's there. So the greatest risk of liability for the vets is the standard report, the one we showed you at the beginning. And if all you write is no significant finding, it's going to be very difficult to defend that. When we were at the AAEP in Vegas in December, I cross-examined Jeff using the report that's in front of you now and then the report that follows. And we made the point to the people that were there that it's a lot easier as a veterinarian to defend your report if you've listed the findings than it is if you just say NSF. Because the argument will be, you failed to disclose something, it's a finding, why didn't you put it on the report?
So you can see there's an inherent problem here, because to find that fine line where you are writing down what you need to write down in order to protect the consignor and the veterinarian without writing too much and without writing too little. And it's basically become like an art form. It's not, there's no standard out there that tells us, you know, and so you as consignors are obviously frustrated, because on the one hand, you don't want your veterinarian writing down on your radiographic reports things that aren't quote unquote important, because people don't understand what's written there. All they want is an NSF. And so you want to minimize the writing down of things that aren't important, but on the other hand, you will have to write certain things down that might keep you out of trouble, keep the horse from being returned, or you know, any number of issues associated with not having the information on the sheet. So it's a pretty tough situation that you all are trying to grapple with right now. I mean, that's why this is one of the topics for today's discussion, because I think it's very timely. Everybody is dealing with this right now.
What's really ironic about where we are is, you know, we started the repository to make the buyer go do their due diligence, to make all the information that they need to evaluate the animal available to them for their veterinarian to review before they bid on that horse. And we've come all the way now to the point where we have significant buyers, some of them my clients, who aren't doing any due diligence. They just rely on the sheets and what they're told, and if it turns out to be wrong after the sale, they're back at the barn trying to give the horse back.
And I have a real-life example that illustrates the problem. I represented a veterinarian in a threatened civil suit that didn't go anywhere, but the administrative action did. The veterinarian used the standard report. He doesn't anymore, but he did at the time. He radiographed all the yearlings or prospective yearlings for a consignor, and there was a finding that he found on one of them. He had his two partners, including a board-certified radiologist, review the films as well. One of his partners saw the finding, the other didn't. The three of them sat and said, okay, there's a lesion there. Does anyone really believe this is going to impact this horse's ability to train a race? All three said no. They went and met with their client, showed him the film. All three of them sat down and discussed what they saw. All four people in that room were comfortable putting no significant findings. The horse was sold. After the horse was sold, the buyer immediately went to their veterinarian, who they had worked with, but waited until after the sale to have the report reviewed. The veterinarian saw the finding, said, I don't know if it's significant or not, it's not on the report. The buyer immediately went back and argued to return the horse. Of course, the horse wasn't returned. It was reduced by 25%. Then the buyer filed the complaint with the Kentucky Board of Veterinary Examiners. Their first response was to suspend for a year. That's the case that we litigated for about 18 months before the board eventually walked away from the case, understanding that the veterinarian in that case had done something that not many of my clients have done, but had sat down with multiple veterinarians for the review and also with their client in coming to a consensus. The important part was all of that work was done. The problem was there was still something that the buyer could see on the report that they determined after the fact was material and used that to negotiate a lower price. And just human nature being what it is, after a sale, if you're someone who might be inclined to try to look at getting a reduced price, don't you think anything that pops on a report, as benign as it may be, is suddenly going to become material or significant to that buyer? And that's the situation we're in now.
The other thing we didn't really talk about, and I'd like Jeff to comment on it, is just assume for a second that these reports are so subjective that there's no way to really agree among veterinarians even about what is and what isn't significant. So when, Jeff, you want to talk about when you all reviewed the reports?
Right. We've had concerns about this for some time, and about 3 years ago, a group of 10 non-affiliated veterinarians, representatives from each of the major practices and some individual practices in Lexington, got together and we reviewed our own reports from the one of the major yearling sales, and any report that had what we would consider a significant finding, of course that's subjective, but what we would consider significant, we asked to receive the consignor's report to see what the consignor's veterinarian said, just to see if they matched up. And of the reports that had the significant findings for all 10 of us, we ended up reviewing radiograph. We then went and reviewed the radiographs to see who was right, because it's entirely possible that on any given horse, I might have found something I thought was significant, and the rest of the group, who aren't even in my practice, might say, hey, Jeff, we think you're being a little hard on that horse. We think the consignor's report is correct. That's always a possibility. So we went through as a group and did this and reviewed the radiographs and then decided which report, whether the reports matched up and whether we thought they were accurate. And of these horses that we considered to have significant findings, there's 392 horses that we reviewed x-rays on, and 49% of them, the consignor's report generated by the consignor's veterinarian did not match what we thought as a group of 10 unaffiliated veterinarians. So that's a problem, and that doesn't mean, what it doesn't mean that there's a rotten veterinarian out there writing bad reports. It's a systemic problem. It's inherent in the system. And again, it goes back to what we talked about the subjectivity of this. And we're like Mike Casey said, we're not talking about the few bad apples. We're not talking about the people that are trying to do wrong. We're talking about people that are trying to do the right thing, veterinarians that are trying to write accurate reports without writing too much or too little, and consignors that are trying to accurately represent their horses according to the information that they're getting from their veterinarians. And so we're not talking about trying, that's a whole different realm that we're not really trying to address today. We're talking about the everyday issues that you and we face in the attempt to create information for buyers. Okay. Okay, so that's the end of that slideshow. I can, guys, you can either speak or I can throw out a couple more examples of things that have happened. I think everybody's getting the point here, and we're actually just a few minutes away from being done, so I think we'll just go ahead and...
Did you have another Bill?
Oh, yeah, I'm sorry, Bill.
That's all right.
Yeah, go ahead. It's open for anybody to...
Please, you guys finish up, and then I'll
Why
get
don't
up.
you go ahead?
Okay.
Yeah.
Well, let me come up there. I want to begin by complimenting Bobby Spaulding on his winter beard. I hope the duck hunting was good in Arkansas. Same topic, different approach. I'd like to try to make this, give you a little bit more context, real context, for how these things come about. You walk into a litigator's office. You and I were in law school together, so you know well what's going to happen. It's going to start like the first time you go see a doctor, and he's going to take a history, and he's going to get the facts. Then it's going to change because the litigator is going to start thinking in terms of causes of action. In a lawsuit, you can have multiple causes of action. You've maybe seen a complaint, count 1, count 2, count 3, count 4, count 5. That's 5 causes of action. Each one of those causes of action has its own discrete set of elements. And if you, Knox, as the plaintiff, don't meet after certain discovery each of those elements, you get thrown out of court on a motion to dismiss, on a motion for summary judgment, but it's something that happens before trial. If you have evidence that meets each of the elements, then you can survive and go forward to trial. So when I asked you about the facts, here's what you told me. A vet issues an opinion. It can be written, typically, or it can be oral to a seller. And that's really important. Who is the report issued to? Typically, the seller. The buyer then arguably relies upon the opinion in making a decision to bid or to purchase. The opinion, in the opinion of the buyer, turns out to be incorrect or, and this is important, incomplete. Now, that opinion may be in the repository, typically, may not be in the repository, may be used right back there. And I'm not so sure that makes any difference, and we'll talk about that in a minute. Now, what are the causes of action that I've heard about today, and I've heard about in prior presentations by these fine gentlemen? They are essentially 4. Breach of contract, breach of a warranty. Those are sort of the same thing. We'll talk through them. Breach of fiduciary obligation, negligent misrepresentation, and fraud. Now, breach of contract. You tell me about this, Nux, and I'm sitting there and I say to myself, it won't fly. Breach of contract will not fly. Why? Because there has to be one of those elements, there has to be privity, or, as doctors said, a relationship between the person giving the opinion and the person who paid for the opinion, typically the seller. So absent that privity or connection between the vet and the person complaining, there is no breach of contract action, in my humble opinion. So what does that mean? Can a seller who contracts with the vet to do a service sue the vet for not doing a good job? Yes. Under breach of contract? Yes. Can the buyer who did not contract with the vet sue the vet for breach of contract for not doing a good job? No. Can the buyer sue the vet for breach of warranty? You know, I'm warranting that this horse is going to be the next honor code. No. Again, for the same reason, privity, lack of that element, kills those two causes of action, in my humble opinion. And there is case law, both Kentucky, Sixth Circuit, which is the federal court for Kentucky, and statutory case law as well. And these are not old cases. Mr. Meusser mentioned that Cohen was 30 years old. These are in the 2000s, and they're good law. I don't see breach of warranty. I don't see breach of contract, and I don't see breach of fiduciary relations for the same reason. Everybody here knows what a fiduciary is. You know, I go, oh gosh, what would be the best analogy? I go to my bank and I say, I want to borrow $100,000 because I've got a really good idea. And the president of the bank says, we're not going to lend it to you. But then he goes out the door and down the street and he talks to his buddy who's on the board and says, boy, Hoskins had a really good idea. Let's go do that.